The problem with California law right now is that the law doesn't distinguish between a squatter and a tenant on its face. And squatters have gotten roped into this classification of being deemed a tenant. And that's dangerous, because it puts the law in a situation where it's emboldening con artists and people who are breaking into homes and saying, you can do this and still be protected if you do it the right way and you know the lingo. Tell the police officers tenant rights, civil rights, and then all of a sudden you have free access to utilize someone else's property. It's a shame because we've really found ourselves now in a place where we basically legalizing theft. From what I've seen in court, someone who was squatting in property was asked questions by a judge. The judge was trying to ascertain whether they actually lived at the property or not. Do you have a lease? How do you know the property owner? And the squatter says, well, the law says I don't need to know the property owner. And the judge looks at him and says, what? And the squatter says, yeah, well, under evidence code section, the individual who was squatting in that particular property looks up at the judge, very confident and very knowledgeable about the law, starts quoting the civil code, the evidence code, and says, oh, well, my rights are protected pursuant to. And I said, wow, this person sounds more articulate than their lawyer. So how did that happen? I'm just appalled. I'm listening to this guy really tell the judge about what the law is, as if the judge didn't know himself. The judge was flustered, the squatter was confident, and I was confused. He basically, to me, he was saying, this is my business, this is what I do. You're not gonna talk me out of this when I know what my rights are. That illustration, I mean, it was just very evident for everybody in the court to see this guy is playing the system, he's winning, and there's nothing even anyone can do about it.